Assalamualaikum and hello. My name is Farah Waida binti Muhammad. My matric number is 1232184. So today I will present question A, which is the evidence that can be presented in the court to support the prosecution case against Salim and Rosie. First, before discussing the specific evidence, I would like to briefly explain the definition of evidence. So, according to Ibn Qayyim, evidence include anything that clarifies, explain or prove a position, right or interest which may assist the court in delivering justice. Besides, Dr. Mahmud Saedon defined that evidence as anything required by the court to arrive at a just decision and which is relevant to the matter in dispute. Under Section 3 of the Sharia Court Evidence Act 1997, evidence include bayinah, syahadah, oral evidence, documentary evidence, qarinah and expert evidence. In this case, the prosecution may rely on several forms of evidence. The first is the witness's testimony, which falls under oral evidence. The first witness is Zali, who is the complainant and also Rosie's husband. Zali was stranded in Osaka, Japan from February until July 2022 due to COVID-19 border closure. During that period, he had no physical contact or access to Rosie. Later, he became suspicious regarding the legitimacy of the baby born in February 2022. He also stated that Salim frequently visited the matrimonial home during his absence. This testimony is very important because it supports the prosecution argument that there was opportunity and possible illicit between Salim and Rosie, while Zali was outside. Next, the prosecution may call Mak Teh and Pak Daud as independent witnesses. They are neighbors who testified that they saw a red BMW car with a registration number VW1234 which belonged to Salim, frequently parked at the matrimonial house. They also confirmed that Salim regularly visited Rosie during Zali's absence. Their testimony strengthened the prosecution case because it corroborates Zali's statement and provides independent observation from the third parties. Besides oral evidence, the prosecution may also rely on medical evidence from Dr. Yohana. Dr. Yohana conducted regular monthly check-up on Rosie throughout her pregnancy. As an expert witness, she may confirm that the pregnancy timeline and estimate the conception period of the baby. This evidence is highly relevant because the estimated conception period may coincide with the time when Zali was stranded overseas. Therefore, it may support the allegation that another man, namely Salim, could be connected to the pregnancy. Apart from that, documentary evidence may also be presented before the court. For example, include Rosie's medical record, pregnancy reports, clinic appointment record, and travel document showing that Zali was outside Malaysia during the relevant period. The prosecution may also produce vehicle registration document to prove that the BMW car belongs to Salim. In addition, the prosecution may rely on qarinah, which refers to circumstantial evidence or surrounding circumstances that may lead the court to infer a particular fact. For example, the frequent visits by Salim to Rosie's house, the absence of Zali during the possible conception period, and the consistency between witnesses' testimony and medical finding may collectively form qarinah supporting the prosecution case. In conclusion, the prosecution may rely on various forms of evidence such as oral testimony, documentary evidence, expert medical evidence, and qarinah to establish the fact against Salim and Rosie. All these forms of evidence are relevant in assisting the court to reach a fair and just decision. So that's all from me. Thank you.
Assalamualaikum, and may it please the court. I am Anis Nabilah binti Muhammad Rizal, appearing as senior counsel for the prosecution, together with my learned co-counsel Nur Haizura, Fatima Az-Zahra, and Nur Shafinas. My lady, this submission concerns the admissibility and legitimacy of Qarina under the Sharia Court Evidence Federal Territories Act 1997, also known as Act 561. The defense has raised a preliminary objection against the use of Qarina as evidence. However, the prosecution respectfully submits that such objection is entirely without merit because Qarina is expressly recognized under Act 561 as well as Islamic legal principle derived from the Quran and Sunnah. My lady, the admissibility of Qarina is clearly codified under Act 561. Firstly, Section 3 provides the statutory definitions of Qarina as fact connected with another fact in any manner recognized by the Act. Secondly, Section 5 expressly allows evidence to be given of fact in issue and all relevant facts declared as Qarina. Therefore, the court has statutory authority to admit such evidence. Further, Section 7, 8, and 11 directly apply to the present case. Under Section 7, cause and effect connected to the offence may constitute Qarina. Here, the pregnancy and birth of the child during the husband's absence operate as a strong surrounding circumstances. Under Section 8, conduct before and after the alleged offence is relevant. Salim's repeatedly visits to Rosie matrimonial home during Zali's absence demonstrates opportunity as suspicious conduct. Finally, Section 11 recognizes a fact that make an allegation highly probable. When the medical timeline, the husband's absence in Japan, and Salim's presence are considered together, the allegation of unlawful sexual intercourse become highly probable. In conclusion, Qarina is admissible because it is clearly recognized under Act 561 and Islamic law. Section 33 allows expert opinion as Qarina, which is relevant through Dr. Yohana's medical evidence. Section 73 and 74 place the burden of proof upon the prosecution, while Section 78 stated that facts, especially within the knowledge of the accused, may be considered by the court. Although there is no confession in this case, the surrounding circumstances strongly support the allegation against Salims and Rosie. Therefore, Qarina is not contrary to Islamic law or Act 561. Instead, it is important evidential tools to assist the Sharia court in achieving justice. Therefore, the prosecution respectfully submit that Qarina is admissible and sufficient to support the case against the accused persons.
With the court's permission, my lady, first of all, I would like to thank my learned senior counsel for explaining the statutory basis of our case. My lady, my name is Fatima Azhara binti Shahrim as the co-counsel for the prosecution, and my matrix number is 1232256. And my part is to show that our argument is not only supported by written law, but is also deeply rooted in classical Islamic jurisprudence. The position we are advancing reflects the majority view of the Jumhur Ulama that Qarina al-Qawiyah or strong circumstantial evidence can be accepted by the court as reliable proof in order to uphold justice. First, my lady, I would like to bring the court's attention to the Holy Quran itself, where physical and circumstantial evidence was used to uncover the truth. We can see this clearly in the story of Prophet Yusuf alayhi salam. In Surah Yusuf, verses 16 to 18, Prophet Yusuf's brothers came to their father with Yusuf's shirt covered in blood, claiming that he had been attacked by a wolf. However, Prophet Yaqub alayhi salam noticed something suspicious. Although the shirt had blood on it, it was not torn at all. From this inconsistency alone, he understood that their story was false. This is an example of Qarina being used to expose a fabricated claim. Then in Surah Yusuf, verses 25 to 28, another dispute arose when Prophet Yusuf was accused of wrongdoing. A practical test was suggested. If the sheet was torn from the front, Yusuf would be guilty. but if it was torn from the back, it would show that he was trying to escape. So when the shirt was found torn from behind, it became a clear evidence supporting Prophet Yusuf's innocence. My lady, the relevance to the present case is straightforward. Just as the position of the tear on the shirt became an important indicator of truth, the biological timeline in this case, a normal gestation period together with complete physical separation across international borders, forms a very strong qarina pointing toward the truth of what happened. Moving on, my lady, the sunnah and practice of the Prophet also support this principle. We can refer to the well-known judgment of Prophet Sulaiman alaihi salam, where two women both claim to be the mother of the same child. Prophet Sulaiman proposed that the child be divided into two. One woman agreed, but the other immediately begged for the child to be spared, even if it meant giving up her claim. From her emotional reaction and protective instinct, Prophet Sulaiman identified her as the true mother. Here, behavioral conduct itself was treated as qarina. Similarly, during the time of Prophet Muhammad SAW, there were cases involving lost property. The Prophet accepted detailed and accurate descriptions of the hidden characteristics of an item as proof of ownership. The reasoning is because when specific facts align perfectly, they become reliable indicators of truth. My lady, the same approach was continued by the Sahaba and later Islamic jurists. Sayyidina Umar ibn al-Khattab established an important precedent relating closely to the issue before this court. He held that a pregnancy occurring without a lawful access to a husband could amount to qarina of zina unless there was evidence of coercion or other lawful explanation. This approach was later accepted by Imam Malik and Imam Ahmad ibn Hanbal. Although Imam Abu Hanifah and Imam Shafi'i were more cautious when it came to imposing hudud punishments, they still recognize the value of circumstantial evidence in ta'zir cases, especially where public morality and justice were concerned. We also see examples in alcohol consumption cases, where Sayyidina Umar and Abdullah ibn Mas'ud imposed punishment based on clear physical indicators such as the smell of alcohol or traces found in vomit. These were accepted because the surrounding circumstances strongly pointed toward the prohibited act. Finally, my lady, classical scholars further strengthen this principle. One important scholar is Ibn Qayyim al-Jawziyah in his work At-Turuq al-Hukmiyah. He explained that bayinah, meaning proof, is not limited only to eyewitness testimony or confession. Instead, it includes any clear sign or indicator that reveals the truth. In ta'zir prosecutions, the required standard is zan al-ghalib, meaning a strong and overwhelming probability. In this case, when the husband was physically unable to access his wife due to international border restrictions during the pandemic, and the child's birth timeline directly corresponds with that separation period, the circumstances strongly support the prosecution's case. Therefore, my lady, we respectfully submit that Islamic law does not prevent this court from relying on strong circumstantial evidence. Justice is not limited only to direct eyewitness testimony, especially in situations where the surrounding facts clearly reveal the truth. To conclude my submissions and demonstrate how these Islamic principles are reflected in modern Malaysian Sharia court decisions, I now respectfully pass the floor to my learned co-counsel. Thank you for your time and indulgence, and may it please this honourable court.
Assalamualaikum warahmatullahi wabarakatuh. My name is Nurhaizura binti Zakaria. My metric number is 1232177. With the permission of the court, my lady, I shall now direct the court's attention to the slide of decided case. To completely reinforce the prosecution position, we will look at the specific facts, legal rules and direct application of three landmark Syariah court precedents. So, the first case is Pegawai Pendakwa Raya Muiz and Haji Adik bin Datuk Said. So, in this case, the accused was charged with committing illegal sexual intercourse. The prosecution did not have any eyewitnesses who saw the actual physical act of intimacy take place, which is exactly the challenge we face in today's trial. So, my lady, despite the absence of direct witnesses, the court established that Syariah court fully accept qarina to determine and establish the truth in sexual offences when direct physical eyewitnesses to the act are unavailable. So applying to the present case, the defense will inevitably argue that because no one physically saw the act of intimacy between Salim and Rosie, the charge must fail. However, applying the factual precedent of Haji Adib, the lack of direct physical eyewitnesses does not defeat or weaken our case. Corina stands as a valid sufficient substitute to establish that the offence occurred. And my lady, we move to the second case, which is Ri Fauziah binti Sa'ari. This case involved a dispute over whether a deceased husband had made a valid matrimonial reconciliation rujuk with his wife during her waiting period. There was no direct verbal or written eyewitness testimony, which is shahadah, proving the reconciliation. However, the court looked at the couple's conduct. The fact that the husband routinely returned to the house, slept in the wife's room, and signed a housing loan document admitting she was his wife. My lady, the Sharia Appeal Court ruled that the cumulative statements of witnesses regarding an individual's conduct and behaviour constitute valid corina to prove an overall fact in issue. So we apply this directly to our case. The testimonies of Mak Teh and Pak Daud. Their repeated accounts of seeing Salim's red BMW parked at the matrimonial home during Zali's absence represent a clear, undisputed pattern of conduct. Just as the husband's behaviour in Ri Fauziah proved a reconciliation, Salim's highly suspicious behaviour must be admitted by this court as strong circumstantial proof of opportunity and inclination. And the last case is Pendakwa Syari'i Kelantan and Yusundi Josan. So the first of the case is the accused person in this matter were charged with the Syariah criminal offence of consuming liquor. To secure a conviction without relying solely on oral testimony, the prosecution tendered physical exhibits found at the scene, which is 2 bottles of Carlsberg beer, glasses, and a payment receipt. So, my lady, the court ruled that physical and documentary exhibits found or recorded in connection to an offence serve as powerful independent corina to secure a criminal conviction. So, applying to the present case, following the exact blueprint of Yusundi Johnson, the prosecution today tenders concrete documentary data. Zali's official travel logs proving total non-access due to global COVID-19 alongside Salim's vehicle registration records, physical and documentary exhibits. Just a bottle and receipt in Kelantan prove the illegal consumption of liquor. Our travel logs and vehicle data are fully admissible physical proof that establish an illicit union. Therefore, my lady, based on the facts and rulings of these 3 concurrent authorities, the prosecution submits that our evidence is legally unassailable, and we pray that all corina be formally admitted into the court. Thank you, my lady.
It becomes clear that the defense objection cannot stand. The prosecution is not relying on a single weak or isolated circumstance. Rather, the prosecution presents a chain of consistent and mutually supporting facts which, when viewed together, establish a strong inference against both accused persons. The first one, the medical evidence presented by Dr. Yuhana clearly established the biological timeline of the pregnancy. The evidence proved that the conception occurred during the exact period when Zali was stranded in Japan. The second one, the testimonies of the neighbors, namely Mak Teh and Pak Daud, consistently placed Salim at Rosie's residence during the same time frame. Their repeated observations strengthen the connection between the accused and the fact in the issue. Taken collectively, these facts form strong
qarinah under Sharia law. The evidence is interconnected, credible, and directly relevant to the alleged offense. My lady, if the defense argument is accepted and qarinah is excluded entirely, it would create a dangerous precedent for the administration of Sharia criminal justice. Offenses committed privately beyond the presence of 4 eyewitnesses would become nearly impossible to prove. Such an interpretation would undermine the very purpose and integrity of the Sharia legal framework. Therefore, the prosecution respectfully prays that this Honorable Sharia Court, firstly, to overrule and dismiss the preliminary objection raised by the learned Perguam Syar'i regarding the admissibility of qarinah evidence. Secondly, to admit all testimonies given by Zali, Mate, and Pak Daud, together with the medical evidence and records presented by Dr. Yuhana as valid and admissible evidence before this court. Third one, to declare that the prosecution has successfully established a prima facie case against both Salim and Rosie and accordingly order both accused persons to enter their defense. We humbly submit accordingly, my lady, that shall conclude the prosecution's submission. We respectfully thank this Honorable Sharia Court for its time and consideration. Much obliged, my lady.